Let me introduce our next speaker, JDavis Powell. Is licensed to practice law in both Louisiana and Mississippi and has a primary practice involving oil and gas law and associated property issues for land, mineral, and royalty owners. A 2001 graduate of Millsaps College in Jackson, Mississippi, and a 2005 graduate of the University of Mississippi School of Law in Oxford, Mississippi. Davis is a member of the Louisiana Bar Association, the Mississippi Bar Association, and currently serves as a board member for the National Association of Royalty Owners, the Louisiana chapter. Please give a warm welcome to Davis Powell.
Did you turn it on?
I don't think so. Can everybody hear me okay? Or is it magnified? No.
You may have to
How about now? A little better? Okay. Good morning. This is the Louisiana session. How many of y'all were in here for the Mississippi session right before? Okay, just one or two. It's going to be very similar. We're going to go over some similar topics, but I'm going to try to do it from my angle. It's going to be from a Louisiana legal angle, but at the same time, my practice is pretty much 90% from the landowner property owner side, and so at times I see things a little different than attorneys that represent the oil company side. So we'll go over some of those same issues, and I'll try to give you my take on a lot of those. As they said when they were introducing me, my name is Davis Powell. I'm from Shreveport. My primary practice is oil and gas and associated property issues. I'm originally from Jackson, Mississippi, so not far from here. Moved over to Louisiana about 5 years ago, and I've always kind of practiced on both sides of the river, even though most of it's in Louisiana now. We're going to have a question and answer at the end, but we have a good, concise group here. We can answer questions whenever you have them. So don't worry about stopping it. I think it's good to talk about it as soon as it pops into your head. Both Louisiana and Mississippi over the past, 5 to 10 years have seen an increase in drilling. Over in the Shreveport area, we of course had a similar play to the Tuscaloosa, even though it moved a little faster at the time. And you see an increase in the number of lessors. We're seeing that over here. You're seeing activity in areas that before did not have traditional oil and gas activity or production before. And so you get a lot of landowners that are new participants in this industry. And so I think it's really great that this group is organized. I've been following it on Facebook and have been really impressed with how everybody stay organized and stayed educated going through it, because there's really no other way to do it. It's the best way to get the most out of this play. I can think back before not really before the internet, but just maybe, 7 or 8 years ago, the most organization you saw was one neighbor and another neighbor asking, how much did you get per acre? And that was just about it. And now everybody has all these educational outlets and can really get better leasing, better terms, and know more about the process. Now, if you don't mind, I'd like to show of hands just real quick so I can know how many are leased right now. Pretty much everybody, okay. Is everybody a Louisiana landowner? Is that, for the most part, is anybody both Mississippi and Louisiana? Okay, we got a few of those. Anybody unleased at all? No? Okay. I do talk about unleased a little bit. We'll lessen that since we don't have as many in here, but I do think it's important since we've seen a lot more unleased issues come about, and you may know somebody or you may have other acres that may end up in that position. Now, the first topic I'm going to discuss is we have to start with how Louisiana differs from Mississippi, and we could go into all the ways, but the main way, of course, is prescription. Most of you have probably heard of prescription or know it well as Louisiana owners, but the prescription basically is a prescription of non-use for the mineral estate. And so when it is separated from the surface estate, you have a 10-year prescription of non-use. So that if certain activities do not occur within that time, it's going to revert to the surface owner. Does anybody in here just own minerals or just a mineral servitude? Everybody in here is a surface and mineral owner, is that correct? Okay. Is anybody in here subject to a mineral reservation where you own half your minerals and someone else may own the other half? Are there? Okay. And we'll talk about prescription as we go, and if you have any questions, feel free to ask them. But that's the biggest way that Louisiana is going to differ from Mississippi. In Mississippi, of course, if you reserve your minerals or if you sell your minerals, they stay in perpetuity, they stay forever, and it's that way in other states as well. I can remember I was a landman prior to practicing law, and we were doing projects in Mississippi, and I thought this is going to be a great chance to meet landowners. But I spent more time on the phone with people in New York, California, and Chicago, and Texas than I did meeting anybody on the ground because so much of the minerals are reserved and owned by heirs for decades and decades. So in Louisiana, you see a lot more of you're dealing with the direct owner on the ground. And that's important too because you have a lot of surface issues that you're going to be subject to and you have more control over how it's going to affect your surface. A few ways that we're the same as Mississippi. The main way I can think of from a legal perspective is that we're all under the umbrella of the Fifth Circuit. And so even though the laws of the states are different and some of the cases are going to be decided based on the state law, all cases really, especially in the federal context, there is an opportunity to end up in the same spot under that Fifth Circuit umbrella. So some of the cases that get decided in the federal jurisdiction can have limited application over both of the states. So from a legal perspective, that's one way that they have similarities. Now I'm going to start with leasing, even though we're all pretty much leased. We still want to go over a couple of topics. And you want to think about your lease while we're discussing these, and if you have any questions, please ask them. But leasing is kind of the first phase, and most of us have been through it. How many have leased just in the past year? And how many have leased further back, I guess, in the past? Okay. Because there have been multiple waves in the Tuscaloosa. I've seen, there were people taking leases here for 5-year terms and 5-year options back in, it was many years ago that I could remember it. But so some of you may have been leased more recently, some of you may have been leased further back. Is anybody within their option term right now? You've had your option exercise? Okay. Well, you're very familiar with your lease. You have your base form in your exhibit, and the presenter before me discussed how you have all these forms back probably 5 to 10 years ago that would have a stamp at the top, and it would basically tell you what's in the form. And we don't really have that anymore. You may still see stamps at the top that say a producer's 88 or a bath form, North Louisiana bath form, South Louisiana bath form, but most of the forms are customized today. So you can't assume that anything's in your lease or not in your lease. You just have to read it. And as an attorney, I have to read it. I can never assume just because it looks similar to the lease I just read. A lot of these guys are customizing the leases. Sometimes they leave the stamp at the top and change things within the small print. So it always pays to read through your lease, and even while you're leased, read through it every year or so to know what's in it. Obviously, bonus and royalty I find to be the simplest part of negotiation. Yeah, for some reason, it's the part of negotiation that people spend the most time on. And that makes sense. It is the financial part of it. But the other big picture concepts with leasing that I find are, the first one is how long is the lease for? You're going to have a primary term. Some of them have option terms. And it's important to remember that the option term is always at the company's option. I remember a client that came in and he was explaining his lease to me, and by saying it's a 3-year term and then they have to come back and pay me again in 3 years. And I said, well, they don't have to do anything. So it's always their option on that. And I have seen companies let options go and then actually come back a little while later and take leases again because they felt the option price was too high for the market. And what other ways that the lease can be held when you say how long the lease is for? Well, a lease can be pretty much forever if the well's producing. We're all thinking about the Tuscaloosa wells, and we're thinking about the initial production, and people are using terms like IP and barrels per day, but you have to think about this in a very long context because you could be held by production 20, 30 years from now under the same lease. You could be held, it could be generations down that are still held by the same lease. And you want to think about it in the context of when the production dwindles, am I still held? What can hold me? Because it's everybody likes it when there's a great deal of production. Nobody complains about being held by a lease. But as soon as the production goes down or the wells mature and no other drilling is taking place, you start to get a lot of questions about why am I still subject to this lease? And you'll hear the phrase in Louisiana law a lot called paying quantities. And you'll see it in case law a lot. The problem is that there's no exact definition. I can't give you a number of barrels, number of MCF that are going to equate to paying quantities. Most of those cases that we see are decided based solely on those specific facts. And so there's really no way to tell. But you do want to consider that going forward and think about your lease in good times and bad. What does it say? How long can they hold me when there's barely any production? Now, when there's no production, you have other clauses within your lease, such as a shut-in clause. That's the one I'm going to discuss. The speaker before me mentioned that shut-in wasn't that important. He didn't necessarily say that. He just said, well, we're in the Tuscaloosa. You're not going to see shut-in be that big of a deal. Well, I would agree with him. In an oil play, shut-in is not always the most important clause in the contract. But I don't like to think of an oil and gas contract just by the play that we're talking about today. Because unless you have a Pew clause that cuts off both below and above the formation being produced, and you know they're only going to produce oil, you can't really write your lease or think about your lease just in the oil context. So a shut-in clause gives the operator some flexibility to keep the lease going even when there's no production. And a lot of times you'll see this when they're trying to get the pipeline ready, or in some cases with natural gas when there's no market for it at the time, or the price is so low they'll shut them in, and they can pay the landowner kind of a nominal fee per acre to keep the lease going. You want to know what your shut-in clause says, even though we're in an oil context. That doesn't mean that 6 years down the road, the company that produced the Tuscaloosa won't assign some of the uphole rights to a smaller company that comes in and produces a different formation. It may be all gas. So it's important to still realize that even the non-oil clauses or the clauses that don't apply as much are still important. Now, I just mentioned Pew clauses, and that gets into another big picture issue with these leases. What does my lease cover? And everybody will answer, well, it covers the minerals. Well, okay, it covers the minerals that are described in the acreage description. But how deep? No. And I assume everybody in here, I'm making the assumption, but everybody's familiar with the Pew clause. Everybody's heard of the Pew clause. Some of the older leases aren't going to have them. Sometimes they were not negotiated in some of the older leases, but a Pew clause, of course, separates out the acreage that's not in a producing unit so that it's not held by the lease. Especially, this is really important in the Tuscaloosa context. If you see in these Florida parishes, the way they're drawing these units, they're drawing in certain directions, and the way that the sections are set up, they're cutting into certain sections and cutting out. Sometimes they do look like large rectangles, but they may only cut you in for a certain amount of acreage. And if you have a Pew clause, you're protected that the rest of your acres won't be held by just that little bit of production. The other type of Pew clause is what I call a depth Pew clause. The speaker before me and a lot of attorneys and landmen will call them vertical Pew clauses and horizontal Pew clauses. And I did too until a geologist in Lafayette beat his fist on the table and said that I had them backwards. And he swore that I had them backwards because he said that the horizontal is for horizons and vertical is for the surface. And so I said, rather than upset anybody, I'm just going to call them the Pew clause and the depth Pew. So the depth Pew is one that we've seen more in the past few years, especially in these shale plays, but it will cut off a certain depth below what is producing. And if you have a lot of negotiating power, some people have Pew clauses or depth Pews that cut off above and below the formation. I would say those are pretty rare. If I can get them, I always try to, but they're pretty rare. The wording of the Pew clause is very important because it all sounds the same when you read 5 different Pew clauses. they'll all say something similar to the effect of, the lessee agrees to release 100 feet below the deepest producing formation or the stratigraphic equivalent of the deepest producing formation, either after the primary term or maybe 1 to 2 years after. But you're going to see variations of language in there, and you just want to be a little bit careful and know what yours says, because I see a lot of Pew clauses that come from the company when when we're negotiating with them, they say, oh, don't worry, we have a Pew clause that cuts off the depth. And then they send it to me and it says it cuts off 100 feet below the deepest formation capable of producing. Well, capable and actually producing are a long way apart. And it's kind of a subjective standard. I can guarantee the oil company is going to find many formations that they feel are capable of production when you're ready to release your acreage. So that's something to consider on those. You want something that hopefully is tied to something that's actually producing. A little aside to that is in the Haynesville, there was a certain attorney that wrote a lot of their depth pews as it cuts off below any well to the point where it was drilled and logged. He added the language "and logged." Well, that caused a real headache for the oil companies once he started requesting the releases, because the logs were not exactly to the same depth that they wanted the releases, and it caused a lot of headaches. So, but the attorney was happy and his landowners were happy because it was really in their favor. But just a few words can change what they'll do when that time comes. And I do recommend that when any of your Pew clauses activate, you request a release from the operator, or from your lessee, which may also be the operator. There is a provision in the mineral code. I'll find the citation in a minute because we're going to go over a few of those that allows you to request a release, and they have 30 days to comply on it. The next thing I want to talk about with leasing is surface rights. Now, how many of you are in a producing unit right now? Okay, we've got a couple. How many of you have any surface use on your land right now under the lease? Got a couple, okay. When I ask people what their lease covers, I never hear the word surface. But almost every lease, unless you completely exclude the surface, has some type of component that allows them to use the surface on I guess you'd say, a reasonable basis, even though the language in the lease says as necessary, or as would be reasonably necessary in some cases. Excuse me. So a lot of people that live on their land and lease their mineral rights, in some cases, if you have a small lease, you can get a no service clause. Most leases don't have them, or you can get kind of certain halos, which I would recommend around areas that you don't want drilling activity, to just completely cut them out of the lease. Make them come back to you and negotiate that at the time. If you don't have that, then you're kind of under the terms of the lease. And I can guarantee the company is going to want to do what they need to do that's best for their operations. And under the law right now, there's not really a lot of set standards, more so than, as the attorney who spoke before me, you have the accommodation doctrine, and you have some other case law dealing with correlative rights, which basically are just trying to balance the rights between the lessor and the lessee. But it is balanced a little bit toward the oil and gas operator, because the mineral estate is the dominant estate, and if we don't grant them surface rights, the minerals become worthless at some point. So it is important to know, in the terms of your lease, what can they do, how much do they have to pay me, where can they do it. Another important aspect of surface use is water use. I keep polling everybody, but I like to know and get some information. But how many of you have freshwater sources other than a water well on your land, like a pond or access? Okay. You probably are aware that this type of play uses a lot of water. There are a lot of millionaires in the Barnett Shale, Haynesville Shale, and Eagle Ford Shale that own no minerals, but they own a lot of water, and they sold their water for use in the completion process. So you want to protect your water interest best you can, and you may have already been approached in some cases by the company to purchase water or get access to some water over your property. I like doing those in a separate agreement completely. You probably didn't negotiate that in your lease, or may discuss water, But a lot of times I like to cut out water completely, other than maybe they always have the opportunity to drill a water well for drilling purposes, not for completion purposes. But I like to handle it in a separate agreement. So if you are fortunate enough to have them come to you for water, just know that you want to read your lease and kind of see what it says as to what access they would have. And then if you can, try to get a separate agreement that addresses just that situation, just that operation.
Excuse me.
Yeah.
Can you share with us generally how a landowner is compensated for water?
Sure. The way I've seen in most cases is by the barrel. And I can't give you any quotes on prices in the Tuscaloosa. Y'all may be able to give me quotes, but I've seen everything from 10 cents a barrel to $1 in the Eagle Ford shale. I mean, they were having real trouble getting water in some of that area in South Texas. At the height of the Haynesville, you were seeing some 50 and 60 cents a barrel. And that was just really to get the water off the water side. They were still having to pay owners for some limited access here and there. The other way of payment is they could do a lump sum, which I don't mind either. It's really up to the owner's preference. But a lump sum, you don't have to try to account for how many barrels did they use, how many did they not use, because when they do it by the barrel, I draft the agreement in a way that we can basically audit how many barrels they use. It does become a lot of money. And we have meters out there, and we're able to check the meters, and we have our own meters. But sometimes they'll just say lump sum per well that we complete. And in those cases, it could be definitely in the 5 figures as to what they'll pay you for water for one well. Now, they may not just be getting it off you, they may be getting it off multiple sources. It depends on how much water you have to provide. Yes?
What about a river, a state river?
That's
really not your.
That's right. And then you led me right to where I wanted to go there. In Louisiana, we've had, and Mississippi's getting kind of smart on this as well, but Louisiana, if you go to, how many of you are familiar with Sunrise and Office of Conservation website? If you're not, I would say that's really a great resource, because between Mississippi and Louisiana and even Texas, Louisiana's website is the easiest to use and has the most information. But if you go there and you look and you overlay on their maps where all the state-owned water resources are, it may surprise you to see what they actually claim. And they've been trying to set up these cooperative agreements that basically allow the state to get paid when they're pulling water out of a state bayou or a state water source. Now, sometimes it's obvious. I mean, obviously, if they're pulling water out of a very large, very well-known river, that's obvious, and the state's probably going to be involved there. And you may only be paid for access in that situation rather than getting paid for the water. Now, on these smaller bayous, it really depends on what the company ends up doing. I've seen companies that gladly enter into cooperative agreements and then pay both the landowner and the state. I've seen ones that have ignored the state cooperative agreement completely and just pay the landowner. I guess they're taking the approach of better to ask for forgiveness than permission in those situations.
Is that practice tied to the navigability issue that?
It is a little bit, and we could be here. It's a great issue. In fact, I've got we have 2 cases right now on the Red River on what parts the state owns and what they don't, and we're working on that right now. But it is tied to navigability, but you'd be surprised how much it's really tied to what is below ordinary low water. And to get into that standard, it would take us a long time today, but just know that you may be surprised as to what the state owns and what they don't. And you may just want to be aware of that if you border a bayou and the company comes to you. You may want to ask them, are you entering into a cooperative agreement with the state? Or you may not feel that it's your duty to do that. I can't say that it necessarily is unless you know that it's a state-owned bayou. The other thing I've seen, just to kind of cap that off, that I've seen owners do is they'll be next to a state-owned bayou, and you as the owner do have a right to the water in a state bayou. Especially, for agricultural or other purposes, you have a right to the water. You're a riparian owner. You have a right to use the water in a reasonable fashion. I've seen owners that use the water by pumping it into a pond half a mile away with their own pump system, and then all of a sudden that pond becomes the most popular place to buy water for the oil companies. I can't really condone that. I think that's kind of a scenario that puts you at risk. But you do see that because you do have a right to use the water. It's right now it's really whether you don't necessarily have a right to sell it to others for industrial purposes off your property. And that is all kind of a gray area, so I'm talking in general terms right now. And does anybody have any questions on water? Yes.
My understanding is in Louisiana, you can't use aquifers for fracking.
Well, I would say that's kind of, I'm not to talk in that in general terms as well, but they are trying to protect the aquifers, and I guess I've kind of glazed over that talking about surface water, but within your lease, you definitely want to try to protect water wells so that they're not able to use the water well water, but I've seen them, especially in the Haynesville, they'll fill their frac pits with water wells that they've drilled on the landowner's land. And I've seen where they've been prevented from doing that because of some aquifer issues. So I'm not prepared to say that they cannot use out of the aquifer. I will say that the state has tried to reduce the damage to certain aquifers in sensitive areas. I think it's a balance. I don't think you're going to see as much groundwater being used as we go forward. I think it's a delicate issue. The next, before we get into just some of the royalty clause issues which lead us into items outside of just the lease, I want to talk about indemnification. Most of your leases are going to have some indemnification clause, but that's another clause that you want to reread every year, or at least know what it says and know what your relationship is. Because these operations that are going on are very, very complicated and very, very risky. And y'all probably gotten to see some, and I know that the TMS Facebook page has posted a lot of pictures and some videos. But I've been on site, but not really. I've not had the best access, but I've been on site enough to see that that type of work is not for me. It's very, very risky work. And if it's on your land, you want to make sure you know what your indemnification says, because it's reasonable to know that you shouldn't be liable for anything that occurs from the operator. But at the same time, it's best to know what the lease says, because as we're going to talk about, a lot of Louisiana law looks to the lease first. I can give you all kinds of revised statutes and articles out of the Mineral Code and case law, but a lot of times in the case law, you're going to see the judge, the court, and the attorneys go to the lease first and see how the lease addresses the issue they're talking about. And so that would be, with indemnification, that's one of those that you really want to know what your relationship is regarding liability. Okay, I'm going to talk about the royalty clause because we're going to talk about getting paid royalties. That's kind of why we're all here, and one reason why we all enter into oil and gas leases. In Louisiana, though, just to get into some Louisiana law, since we've just been discussing the leases, there is really no definitive timeline when your first payment is due. Is anybody in pay right now on a well? Is anybody waiting, has a well drilling on them right now? Well, I hope that all of you do at some point on everyone's leases, but in some other states you have it in the statute as to when the first payment is going to be due. Oklahoma has a good statute for that. That's one example. In Louisiana, there's a recent case that it sort of surprised me, but it happened. It's actually ongoing, and it's dealing with Chesapeake. And if you know Chesapeake, they're not really active. I don't see them active in Tuscaloosa right now. However, their name is either famous or notorious, depending on what article you've read. They're in a lot of litigation. You're going to see a lot of case law with Chesapeake's name in it. And this first case is Slattery versus Chesapeake. And if you'd like any of the citations, I have them up here afterwards, and we'll certainly give them to you so you can look it up. But this case is still ongoing in the federal court, but they had a recent summary judgment hearing. And summary judgment, of course, is where you try to dispose of the case before trial. You say there's really no facts at issue here. We just want you to decide it based on what's there. The facts of the case are you have a royalty owner that has a couple of wells drilled on their lease, or they're within units that are producing. And they're excited. The wells are drilled. They appear to be really good producers. And after about 3 months, they're looking in their mailbox and nothing is there. After about 4 months, nothing is there. And they felt about that time, they went to their attorney and they said, we feel that they're late. So they file demand to the company to pay them their royalty. Well, they had a lot of issues that end up in this case, more so than just that one, but the summary judgment addressed whether the payments were even due at that point. And for them to prevail in summary judgment, the law would have to say, yes, they were due after 4 months or after 5 months or a specific time. But the law actually says they're due by the terms of the contract. There again, the judge was going straight to the lease and saying, what does the lease say? Or by industry custom. And industry custom basically is as clear as mud. And you're going to have to prove it through experts if you get into a case over it. So what happened is they lost their summary judgment, and they're going to have to prove that the payments were even due to say that their demand was even worth it. So I always recommend to people that if you do have a chance to lease, or if you have it in your lease, you want to insert some language that gives some type of reasonable time period when the royalties will be first due, and then possibly another period that says, and this many months after the actual production month, the royalty payment is due. The company may come back and try to, or come back and ask for some kind of trapdoors there to say, well, what if we don't have the title opinion ready? Well, that's all reasonable. If they don't have something, they may be able to extend the time, but you want to at least have a set time that you can say, you can look at your watch and you can look at your mailbox and say, I can make demand today and feel comfortable about it. So that's a case that's ongoing right now, and it wasn't necessarily surprising to me, but I was just kind of, I thought, I take it for granted when I make demand that the royalties are being due. And this was the first time I saw the attorneys from the other side say, what if they're due in 8 months? Then we were reasonable at that point. How many of you have heard of no-cost royalty or cost-free royalty? Cost-free royalty has become one of the most litigated topics in all of the shale plays recently. And it's a clause that started to develop over many years, but it basically says, I don't want any of my royalty burdened by post-production charges. And sometimes you don't have the negotiating power to get that clause in there, but I've seen in the Tuscaloosa and the leases that I've negotiated just in the past year, I can get some version of it in there. And the reason is because they say, well, you don't need this, we're dealing with an oil play. And there's not a lot of post-production charges in an oil play. I say, that's fine, but I'm not writing the lease just for the Tuscaloosa because I don't know what the future holds for it. And with natural gas, there is a great deal of post-production charges because there really is no market for it until you get it to the market and you get it ready for the market, whether it be dehydration or processing and compression. So a lot of times when you ask for the no-cost royalty, you may or may not have it in your lease. You may want to look at your lease and see if it addresses it. With oil, it's not going to have a whole lot of application. It may have a little, but not a lot. With natural gas, it can be a great deal of application. I've seen leases that take out 35% deductions. On a big well, that's a lot of money that could have been solved with a couple of sentences in the exhibit. Sometimes the company will come back to you and say, we've got some language that's approved for no-cost royalty. And they'll send it to me and they'll say all the things I like in the first 3 sentences. And then the last one says, but if we do anything that enhances the product, we can charge you for that. It's called an enhancement clause. It really just walks back everything that I'm trying to do with the no cost because everything can really be considered an enhancement if you want to argue that. And companies such as Chesapeake will argue pretty much anything on these clauses. They won a case, not Chesapeake, but the no-cost royalty clause was really weakened back in 1996 with a case called Heritage versus Nations Bank. And this was a Texas case where the court basically saw language in the exhibit that was trying to contradict the royalty clause and say something, speak to the effect of post-production charges, but they were able to read it together and say, no, it doesn't cut them out. They can still charge them. You'll see that case, even though it's a Texas case, you'll see that case mentioned in briefs in almost every state where this is an issue, even up in the Marcellus Shale, up in Pennsylvania, in Ohio, and New York. Recently, though, as people got smarter after Heritage versus Nation Bank, they started writing their clauses more specifically. So if you do have this clause or you have a chance to lease again, you really want to be careful with the clause and write it very, very specifically. The recent case I'm talking about is Chesapeake versus Hyder, and this was the Fourth Court of Appeals in Texas. I think Chesapeake's going to appeal it further, but the landowner won in that case, and it's because their clause was very, very specific as to what the company, what charges they couldn't take out. And I believe in Hyder, they actually said the case of Heritage versus Nations Bank has no application here. They basically said you can't argue that. We're trying to take out post-production charges. So it may not be an issue for your current lease, but if there's other leases, or if you do have it in your lease, it may be an issue in the future because some companies are not recognizing them and basically saying, you sue us and prove it to us that your clause should apply here. And you'll see a lot of variation. Oh, go ahead. Yes.
So could you simply say be paid on the gross amount of production?
Yes, there's kind of two camps on this, the way the attorneys are doing it. There's some attorneys that are writing a clause that's a page long, and there's some attorneys that are writing 3 sentences. And both of them feel they have the best route. They say the simple one is, the less we say, the better, the less they can interpret. The longer one is saying we have to be detailed or they'll find a way around it. I have a couple variations, and attorneys talk about this clause a good bit. I wish that I could write the perfect no-cost clause, because then, just like Mr. Pugh, I could have a clause named after me that would live on. But I don't think that anybody is going to write that perfect clause, because right now it really seems like Chesapeake and some of these other operators don't mind litigating them, if for just the reason to scare off the rest of the owners who may want to litigate it as well, because the litigation will drag out with some of these large companies. And the last point about the no-cost royalty, there was a case over in the Western District federal case in Louisiana, up in Shreveport, called the Magnolia Point Minerals case, where the judge really did the same thing that they did in Heritage versus Nation Bank. He looked at the exhibit. Top of the exhibit said, "This exhibit shall control." It supersedes everything in what I call the base form, the printed form. The printed form allows them to take out post-production charges. There's a clause right below where it says that the exhibit controls that says you can't take out post-production charges. The judge decided that he read those clauses in harmony, is the best way to put it, and says they could take out post-production charges. And everybody just kind of threw up their hands in confusion, because it was a very, very clear case. Well, shortly thereafter, they vacated the judgment. So we are seeing a little bit of progress toward our end, and they're getting a little more reasonable.
Let me ask you a question.
Yes.
If you were doing that, why wasn't it X'd out one of the base lease so it didn't apply?
Right, and that's a good question, whether to strike through or not. And one reason it's hard to strike through in the base lease is because the clause that basically addresses it there addresses a lot of other things. And so when negotiating the cost-free royalty clause, there's a lot of companies whose attorneys are just going to say, we won't do it at all, because once you start striking through in the base form, they get nervous. And I almost do too, because if you strike through things in the base form and you put an exhibit, which I do sometimes when it's clear when we're striking out full clauses, but if you selectively strike through in the base form and you have an exhibit, the judge starts to, I guess, wonder, why was it not all just addressed in the exhibit? You know, do these things, what was the intention if he was trying to strike this out and he was saying this here? I'm not saying that would happen, but with that particular clause, what it says in the form, a lot of the attorneys from the oil companies don't want to touch it. So I'm not saying you can't do that, but I'm saying that I think it is harder to negotiate certain strike-throughs in the base form and then addressing it fully in the exhibit on that particular clause.
I was going to add something.
Yes.
What they'll do is put in front of the clause that you want to insert in the rider, notwithstanding anything to the contrary contained herein, which basically says, even though there may be some language in the printed form about this one goes, the one in the rider.
I mean, there's certain things they need in a lease form, and I don't mean to be so far to the landowner's side that I don't want the companies to come operate on my clients. You know, the whole reason we're in negotiation with them in the first place is because we do want a lease and we do want production. So there are some things in the form that they need. It's kind of like talking about the shut-in clause. I'd love to strike the shut-in clause, but I know that operationally they need that flexibility sometimes. Something else to consider on all these no-cost royalty cases you'll see names in them, and if you run their title and look at the mineral owners, they're 1,000-acre mineral owners, very large families with established production over the years, and attorneys who probably charge as much as Chesapeake attorneys to write the form. So it's not like these attorneys were negligent in writing these forms. It's really just in this judicial interpretation, leaning sometimes toward the operator. And we're seeing a little bit go back and forth now as we get smarter writing these terms and writing them after these other decisions. Okay, we're finally gotten to royalty payments, which is really what I want to talk about today. A lot of y'all may be in the situation right before royalty payments. And if you are, hopefully a lot of what I have to say will be helpful. The first thing I want to talk about as we're going in the timeline here, we talked about leasing. We're about to talk about royalty payments, but prior to royalty payments, we want to talk about division orders. Is everybody familiar with what a division order is? Or has anybody received a division order? Okay. Division order is basically just some correspondence from the company that said it's going to have your name as the owner, your address, or it's the correct address if you received it. It's going to have a decimal associated with that owner. And you want to check the decimal on your division order to make sure it's correct. And the best way to do that is you want to take how many net acres you have in the unit, in the production unit, divided by the number of acres in that production unit, and multiply it by your royalty rate. That's the simplest way to say it. Now, there can be more complications depending on how complicated your ownership is, but that's the simplest way on a basic level. But that's what a division order is really good for, is once you receive it, you want to check their math a little bit. And the best thing about the division order in Louisiana is you don't have to sign it. And I don't sign them because I just don't feel, since there's something in the mineral code that says I don't have to sign it, I don't feel that it's necessary to create any paper trail if it's not necessary to receive the payments. The portion of the mineral code that says you do not have to sign it is Louisiana Revised Statute 31:138.1, paragraph C. The execution of a division order is not a condition precedent to receiving a payment from a lessee. The lessee shall not withhold royalty payments because his lessor has not executed a division order. So I'm not trying to subvert what the oil companies are trying to do for their record keeping, but at the same time, I just see no need in creating that record or signing something attached to that decimal that can be held up later on. And another thing about a division order is, and this doesn't happen often anymore, but there have been companies that have tried to amend terms in the leases with the division order. And they're really not allowed to do that, of course, but that's why they want to get you, that's in those cases they were getting them to sign it, and it actually amended some rights within the lease. Now, the other part of this statute says that it does provide damages if the company refuses to pay the royalty owner based solely on them not signing a division order. Now, this is rare. Every now and then I'll get a division order analyst in Houston that just started working on Louisiana Prospect, and she's still applying Texas law or some other law and requesting the division order before she pays us, and we send a letter that says that cites the statute, and then they pay. If they don't pay after that, then they have a problem. There are damages available to the royalty owner. Now, there is a situation where they can be reasonable in not paying you, and that's if they don't have your correct tax ID, social security number, or address. So as you're looking at your division order, you want to check that information is correct. And if it is, for me, I just say check the decimal and file it away. If anything is incorrect, we always send a letter to the company and say, thank you for the division orders. Here's my name, address, and here's the social security number or tax ID. Please remit payment as soon as possible. Send it certified, return receipt requested, so you know that it arrives, and you're done. But we do that rather than execute the division order. Anybody have any questions on that part of it? Math on what they provide. And so under Louisiana law, I'm going to go over the items that they have to provide to the royalty owner on their checks. Because if they don't, you really need to call and request that, because these are items that you need to do the math from your end. You're their business partner. They're paying you a portion of it. You should be able to calculate it yourself as well. So this is Louisiana Revised Statute 31:212.31. And this is all in the mineral code. And this lists out 9 things that they need to provide. And if you need any of these citations later on, I can provide them to you. If you need me to send you copies of the revised statute, I'd be happy to do it. But the first thing they need to provide is they need to provide some type of lease identification number. They can't jumble all your payments up into one big payment. They need to itemize it by where it's coming from. And so usually that may be the well name or the unit name. But they need to identify exactly where that product's coming from. And if you have multiple wells within a unit, it needs to be itemized by well, not just by the unit, because you want to be able to reconcile each well. The next thing they need to provide is the month in sales of what they're paying for when the month of the sale took place. A lot of times on your check, you're going to be getting paid for months that were 2 months prior. Sometimes on your check, you're going to be getting adjustments. This is a lot of my work is going back and looking at these adjustments and finding underpayments sometimes, but I see times that they will adjust things that were 2 years prior, and they will adjust it on a current check, and it may cause an underpayment. So you want to watch that, but you're able to see which month they're dealing with so that you can go back in your records and decide and reconcile it again. So they have to provide that. They have to provide the total volume or barrels of crude in the Tuscaloosa's case that was sold or purchased. This is important because you can go to the Office of Conservation website and you can check that volume, and it should match. Now, in an oil context, you're dealing with how much oil is produced versus how much oil was actually sold. They have both of those numbers on the Sunrise website, so you're able to reconcile what you're being paid. And that's no small thing either. We have a matter right now that hasn't gone to litigation, but we're in negotiation with an oil company. They underpaid by 6% on the volume for 2.5 years on a Haynesville well. It's a 640-acre unit. The owner has about 150 acres. And this was near the beginning of the Haynesville well. So it is no small amount of money, even though on a month-to-month basis, 6% doesn't look like much. So it always pays to kind of reconcile your statement. The next thing is they have to provide you a price. Sometimes that price is not going to be exactly what you think it's going to be. We have different benchmarks we can look at price. The oil price is easier to verify. With natural gas, it's more difficult because you'll see benchmark prices like the Henry Hub and the EIA price with the government, and your price is going to be a little bit lower a lot of times. That's because the Henry Hub is a little further downstream, and sometimes it's a different scenario than what you're getting in the field. The next thing they have to provide you is the total amount of any type of government taxes. And this includes severance tax. How many are aware of the Severance Tax Relief Act in Louisiana? Okay. Basically, I believe the Tuscaloosa wells qualify for this because they're deep and horizontal. But basically, for the first 2 years of the well, the operator is eligible for refund of the severance tax, or when the well pays out, whichever time is earliest. So you may be getting severance tax taken out on your check, and that's okay, because a lot of times, sometimes they'll retroactively come back and refund it after they have filed their paperwork with the state. Some companies just don't pay it in anticipation of getting their paperwork approved with the state. But it's something you want to watch because it can add up as well. If they haven't refunded your severance tax in the first 2 years of production or so, it's something you want to call or inquire about, because as I'm going to talk about in a minute, there's a 3-year underpayment prescriptive period, and after that time period, the company does have a defense that they don't have to pay you the underpayment. So you don't want to let it go too far if they're taking out severance tax and you may be owed a refund. So it's a payout or 2 years, whichever is earliest. And we hope all these wells pay out very quickly. That would be good. But if not, you have 2 years at least. The next thing you have to provide is your net after all taxes were deducted. They have to provide your owner interest, which should match your division order. Sometimes it doesn't, and that's something you need to look into. Sometimes you'll have an owner interest that goes along for a year at the same interest, and you've already verified it, and then one day it switches. Sometimes it's based on a survey plat that was done when the well was completed, and they do a more accurate survey later on, and everything changes. So you want to keep an eye on that decimal each month, and just make sure it matches what you know your interest to be. Now, one thing that's kind of missing from this list is deductions. It's not explicit in the mineral code. And most companies, I'd say 80%, 90% of them, will show you anything that's deducted, even beyond government taxes. And this is more on the natural gas side of it, but you may see some in the oil as well. But most of the companies are going to show you everything that's deducted to get to your net so that you can do your math. However, it's not explicit in the code, and I know that it's not because that company, again, Chesapeake, does not show deductions sometimes on their checks. They'll just show a price that's what's called a net back price, and that's a price after they've taken out deductions, because that's your final realizable price. So it's something you want to be careful about. Sometimes you may see no deductions, but you see a really low price. They may be taking out deductions. This is an area that I think should be clarified in the mineral code. In Louisiana, we are sort of at a disadvantage with the companies. It's kind of a traditionally they lean toward the oil companies here, but I would like to see something like that put in there. I think it would be fair, and a lot of other states already have it, where they have to show everything. Does anybody have any questions on the voltage check? Yes, sir.
You say check detail. Your list is pretty exhaustive here. Some of them are pretty straightforward. And some of them like volume and price. How would a landowner know the volume is coming out of the ground?
Right. Well, the only way to really check volume, or the best way to check it, I have some landowners that are a little more creative, but the best way to legally check it is to use the Office of Conservation site. You can look up your well on, it's called, some people call it Sunrise, some people call it Sunrise, but you look up your well and you can see the last reported month and try to match it to the one they reported to you. And that's always important. If you have some discrepancy there, or even if you think you do, then call their owner's relations. And that's something I'm going to talk about in a minute, but it's always good to have the owner's relations line for your lessee or whoever's paying you on your refrigerator or on your desk, because you may be talking to them often, and you want to reconcile this and treat it like a business. So that's the best way to look at volume. Now, price is a little different. Price is difficult to peg because there is no set price unless it's in your lease, and it's rarely they'll agree to that in a lease, but there is no set price. So you're seeing a lot of litigation on that right now where, again, they're suing Chesapeake over this, but they're suing some other companies that the price is unreasonable. And they're not able to win any of that on summary judgment because they can't go in there and say, here's what the code says or here's what the lease says. They're bringing all these expensive experts in to decide whether the field price was reasonable, whether it's reasonable within that field. So price is more difficult. What I recommend to owners is get your best feel for the price. Talk to your neighbors, try to understand what prices are being paid in the unit or in similar units around you. And that's the best way to do it. I mean, on the TMS Facebook page, this is a perfect forum, or any other forum, for people to anonymously post what prices they're receiving. And if people are honorable about that, then you can kind of check and see versus other operators and other units near you. So that may just be one idea for in the future.
Is that the only oversight of this process as a landowner, or is there any government oversight for audits?
There is government oversight. The office is pretty thin, but they do try to watch over what they're reporting and whether the volumes are correct. I'll say in Louisiana, I mean, if you just look at the guys they have working on just to make sure the wells get plugged right now, they don't have enough people for that. I mean, we have an orphan list that won't get plugged in the next 15 years, even if they started on it today. The people in the office, I remember calling about a severance tax issue on whether a company got approved for a severance tax. They had 2 people at the office working on it, on all the severance tax relief in Louisiana. And I found that, I don't know that that is exactly the case, but I did find it odd. So You are your best policeman on the royalty check, and you're really the first one that's going to be able to locate that. Yes.
What is the current severance tax for oil production?
I knew I was going to be asked that, and I didn't look it up before I came, but I think it's around 2-point-something%, I believe.
That's with the holiday, or is that the normal tax?
That's the normal tax, I believe. There's just going to be a set tax, and it does change. The legislature may change it. I think the last time it's in effect from July for 2 years or 1 year, but I think it's the same as it was on the last period. But it's not a lot of money, but at the same time, if you have a lot of acreage, it all depends proportionally to what you have. And I don't like to leave any money on the table, so if they're taking out severance and they don't refund it to you, maybe it's something you want to look into eventually.
I would guess you probably go to the Louisiana Department of Revenue and find those rates.
Oh, yeah. And you can find the severance tax rates on, I believe it's probably there, and I think it's also on the Office of Conservation page, just because so many people are asking that question on their frequently asked questions. But I think it's under 3% if I'm right. Now, excuse me, that's on natural gas. I'm not, I've got that on my mind this morning. I apologize, but there is a different rate on oil. And I'm sure we can look that up, or I can get that information.
Another probably thing that people just don't take for granted, don't even worry about it, because I'm satisfied with this check. Like you said, a lot of times they don't look at the detail of it, because if you get a royalty payment, it's going to show gross, taxes, net. And I think everybody probably thinks that the company's paying that, but it's really coming out of your check.
Right.
And then when we'll talk about it later, you get the depletion, you figure it on the gross, because that's what really is yours.
That's right, and of course that's a topic for the CPA, but that's something a lot of people overlook on depletion. Some CPAs may even overlook it in some cases, but something just as simple as you're discussing, they show you gross, and they show you your decimal interest, and they show you net. I've had cases where their math was wrong, just on that. And so I'm not here to be suspicious or make anybody else suspicious, but it's very, very cheap and easy insurance just to check it every month and kind of keep good records. And that's the best mineral management tip I can give.
I think it's true, because that's what we call the older generational thing. They think spreadsheets are perfect.
Right.
They put it in there and they balance and get the totals.
Yeah.
They don't look at the numbers sometimes. Does that look right?
Right. And there are services out there, and there are attorneys that can assist with this, and it's not really a great cost. And so for some larger owners, that may be an answer, is to have it managed. But I always encourage owners that people call this mailbox money, but it's really a business, and you want to run it like a business, because there can be mistakes made, and they're not always made on purpose. But for some reason, we see a lot of them. These are large companies. A lot of times they're overworked. We're seeing a lot of these companies that have one divisional or analyst handling a whole field. She's going to make mistakes a lot of times. He or she, excuse me.
And a lot of times that's the lowest level person in the company that gets assigned to do this.
That's right. But I will say that, and I'll talk about this a little more, but the divisional or analyst, you want to know who your divisional or analyst is. You want to know somebody in owner's relations that you can hopefully get to. It makes it difficult with some companies. You're going to call a 1-800 number, and they're going to make you wait for a call back, and it's very difficult. But you want to try to find some contacts at the company best you can through owner's relations. Now I'm going to talk about, since we've already kind of talked about it, but non-payment and underpayment. And in Louisiana, under the law, we have a 3-year prescriptive statute on underpayments or non-payment. So if you wait beyond 3 years from the occurrence of the underpayment or non-payment, you can lose your right to claim that. It doesn't always work that way. If someone comes to me and some of their underpayment is within the 3 years and some of it's not, I still send demand for all of it, and most companies go ahead and refund all of it or work it out. But in some cases, when it's a long period of time, we've seen cases where the person comes in and says, you haven't paid me royalties for 10 years, and the company files an exception or files a summary judgment in court and say, but we don't owe you for those 7 years. We'll pay you for the 3, but we don't know the other 7. So you want to be careful, and at the very minimum, you want to check all of your payments before the 3-year period. I would suggest definitely more often than that, but at the very minimum, you want to know before you run to the prescriptive period. Now the important word there is from the occurrence of underpayment or the occurrence of non-payment. There's really not an occurrence of non-payment, so that one gets a little more difficult to prove, but with underpayment, the occurrence can be, it may not just be the time that they didn't pay you. Say that we're talking about a production month of July 2014, and we're looking at our September check, and there's an underpayment. Well, that underpayment occurred in September when you received your check. Didn't occur in July. Now, if they adjusted a previous month in September on the September check from, say, 2 years ago, and it caused the underpayment, that is the occurrence of the underpayment, not 2 years ago. So I've seen the company claim that it's where the production month is, but that wouldn't be fair. That doesn't work out because it's when you actually are provided with, or the underpayment exists to you. So, but all that being said, this is another reason to check it because you can be cut out from your claim if it's too old in certain situations. Now, if you do have an underpayment, I'm going to talk about making demand. This is something that it's good to have an attorney do, and I like doing it, and I do a lot of them. But if it's something you want to try yourself, it's something that can be done by the owner themselves as well. You're going to find this in the Mineral Code in 31:137 through 140. This is an area that all deals with how to make demand on your underpayment. And so, you look at your payment and you have an issue with volume, you have an issue with the price, which is more difficult to prove, or you have just an issue that it's not correct for some other reason. You want to document it first, whether that be through a clear narrative that you type out or through a spreadsheet, or if it just is plain as day, you want to include a copy of your check with your letter, but you're going to send them a letter that needs to invoke the Mineral Code statute. Or the best way to do it is to invoke the Mineral Code statute that we're talking about, especially 31:137. You don't want it to be interpreted that you are just sending them a letter and asking a question. It has to be a form of demand. That's one mistake I see people make, is that they want to say that that's the demand, and the company is able to say that it's not. The next thing you want to do with your letter that's as important as citing the Mineral Code and documenting the underpayment is sending it certified return receipt requested. There was an old case, and I can't remember all the details, but I was trying to remember on the way here, where the code said to send it certified and someone sent it registered, and they lost initially on the case, and it just seemed like kind of a picky way to lose a case. So they've changed the code, and I believe it says certified, but for me, for my money, $5 to $6 is very cheap insurance to make sure to be able to prove receipt. And so I just do certified return receipt request on all of it. I keep the certified label, and then when the green card comes back, I keep that in my file as well with a copy of the letter. From the time of their receipt, they have 30 days to respond to you. Now, they really have 30 days to solve the underpayment, but it's more of 30 days to respond, because they can respond with a reasonable reason why there is an underpayment, and that can satisfy the demand for the time being. Most of the time, if you're right, they're going to go ahead and pay you. They're not going to really try to pick a fight with you when they know they're going to lose it later on. So we have some time. Okay, thank you. So most of the time they're going to pay you, but a lot of times they'll give you a reason, and that's when you have to get into whether it's reasonable or not, and that may be the time that you need to hire an attorney on. So, but this is something that you can do yourself if you'd like to. I think it is sometimes better handled by an attorney, because sometimes the letterhead sparks them into action a little faster on it. But that's my opinion. I've seen them respond to any of them. Yes?
Part of the problem with that is that sometimes you understand that you're looking at, say, what Chesapeake's paying you, for example. You've got checks from 5 other operators in the field, and Chesapeake's always, their graph is always below the others over a 3-year period, for instance, in some of the ones I've looked at. And I don't know what I should be paid, but I know I wasn't paid enough.
That's right.
So
That's where it gets difficult. There is you're not going to get penalized for sending in a demand. The only real penalty is that if you send in enough of them that really have no documentation, you run into a crying wolf scenario where, oh, here's Mr. Powell again sending his demand that has no basis in reason. So with price, that's more difficult. That's why I say you really want to look at it and document it. And if it's something that you possibly don't feel that you can prove, that's when you may want to have someone else look at it. It shouldn't be that expensive for an attorney who does oil and gas work to take a look at these and very briefly tell you whether there's something here that we should make demand on.
In my case, I would send the evidence I have of other operators in the same field or well.
Yeah.
Sometimes you're split streaming a well and two companies own it, say Sweppy and
Yeah,
Canada.
right.
And you'll be getting a different price for the same commodity coming out of the same well.
Well, in the Shell and Canada situation, which I have clients in that one as well, you do get different prices, but they each have their own interest in the gas, and they're able to sell it under different contracts. Plains and Chesapeake, yeah, which I think is Freeport now. It's Plains sold to Freeport on some of it. Yeah. But yeah, you're going to run into that. I don't recommend sending demand right away on those. It's really more the ones that you know. You'll get a feel for it, but like I said, if you have an attorney that does oil and gas work, that doesn't have to necessarily read up on it, this is not even an hour to meet with you and kind of look at it and tell whether you have an issue or not. Yes.
On those wells where you have, two companies sharing or whatever, what would you just add both of them gross and go off of there, because one of them is selling for a different price?
Well, it depends on how they're reporting it to you. And unfortunately, it gets complicated when you have two companies. And it should be standardized, but it's not. With the Encana Shell situation, Shell will pay you he'll show you the full volume, and then they'll cut your decimal interest in half. Encana will show you half the volume, and they'll pay you the full decimal interest. And then a year later, they'll change it because their computer system changed, and they'll do it a different way. I can't complain. I've gotten a lot of clients that way because people have just thrown their hands up and said, I give up. But you'll see them change their computer system, which I do find odd. They do that pretty often sometimes. And the next thing you know, your checks look different. You got to start paying attention again and get back in a different mode. So
You should still be able to reconcile it, I would think.
you should. And that's what I'm advocating for, is that I think we should have a little more protection. I don't think the companies lose anything to provide a certain amount of information and make it easy to read and have standardized checks, which is a bad word in the oil company industry. But I think it would be helpful, and I don't think they lose as much on that. Now, I think we're running a little bit out of time, and I was going to get into mineral acres versus royalty acres. I know they wanted us to talk about that real briefly. So I want to say at least that if you're looking at some type of divestment or conveyance of mineral and royalty acres, or mineral interest or royalty interest, just know that the mineral interest is really a greater right. It's a greater bundle of rights. And the royalty is, sometimes it can be just the royalty under the lease, in which case, if the lease expires, the royalty goes with it, or it can be a royalty under that lease or any future lease. So if I see it from a buyer's perspective, those two are really priced differently for me. And in Louisiana, it may be priced differently than Mississippi because you have the prescriptive period. They're almost buying a riskier asset than they would in Mississippi. So I apologize, I kind of missed a couple of topics, but we had some good questions. Does anybody have any other questions that y'all want to ask before we end? We may be all hungry, so I appreciate it. Thank y'all for this opportunity.